The majority of 29 judges that make up the Ninth Circuit Court of Appeals have sent a message to the trial judge, Judge Immergut, in Portland, Oregon, who starts a trial today about whether Donald Trump's mobilization and deployment of the National Guard is proper or not, as she hears evidence, and wait till you hear the evidence of the feds firing tear gas and pepper balls and pepper spray at local law enforcement. Yes, it's the feds firing at cops. That's what this has become, sheer anarchy. And the Ninth Circuit said we're going to vacate a earlier decision on October 20th by 3 judges, 2 Trumpers, to block Judge Immergut's temporary restraining order. They've thrown that order out. And now Judge Immergut's orders stay in place, which means the National Guard has to stay in barracks, right? They can't be deployed while the Ninth Circuit decides on this issue. And wait till you hear about the trial brief that was filed by Oregon and California to inform Judge Immergut of what's going on and the fact that feds are firing at local law enforcement. I'm Michael Popok. This is Wednesday on Legal AF. We got the trial. We got the Ninth Circuit. I'll stitch it all together. We're still waiting on the United States Supreme Court to make a decision about whether the deployment of military and National Guard in Chicago was proper. We're now going on to our second week waiting for that order. So we're sort of talking about things in the shadow of that decision. I might jump back on later today or on Substack Live for Legal AF and tell you we've got a Supreme Court decision and how that impacts all these other decisions around the country. But let's focus now on the Ninth Circuit. Ninth Circuit sits over Oregon, Washington, and California. It sits in San Francisco. Now, in appeals, and I've handled a number of appeals in my career, including at the Ninth Circuit, you get a 3-judge panel. That is 99% of all appeals. When you hear there was an appeal decision, that came from a 3-judge panel. On rare occasion, you can't demand, you can ask for the entirety of the bench or some larger portion of the judges of that circuit to hear the decision and make a new decision. It's called an en banc, E-N-B-A-N-C, en banc. In the Ninth Circuit, if you are granted an en banc, then you get 11 judges to hear your case instead of the 3, and the order by the 3 judges is thrown out. We start all over again. The 11 judges are 10 randomly assigned, could be part of the 3 that originally heard the case, not unusual, and the chief judge. That's your 11. To get your panel of 11, though, you've got to convince the majority of the judges of the circuit to give you en banc review. That means 15 out of the 29 had to vote in favor of that. That means 15 out of 29 are troubled by the decision by the 3-judge panel, 2 Trumpers and 1 Clinton appointee on the October the 20th. That was against Judge Immergut. Now, the makeup of the Ninth Circuit, 1/3 of the Ninth Circuit are Trump appointees from the first term. So you got that in the mix. Now, they know, because they're human beings, that Judge Immergut, the trial judge in Portland, is holding her trial today about whether to convert her temporary restraining orders into permanent injunctions or preliminary injunctions. So they issued their order, and it's just a 1 paragraph. It is effectively from the chief judge of the Ninth Circuit telling Judge Immergut in the world, we are vacating, throwing out the earlier decision by the 3-judge panel, subject to our making a new decision. And by doing that, you revert back to the decision, to the temporary restraining orders of Judge Immergut, meaning the mobilization was illegal and unconstitutional and the deployment was illegal and unconstitutional. Stay in your barracks. That's why there's no National Guard on the streets of Portland right now. Now, the trial has started, and this is new evidence that I had not known from following the story as closely as I did. I did not know what was happening on the streets. But here is what the parties have told the judge about what to expect at trial. When you have a bench, when you have a judge deciding an issue, a trial or a hearing, and there's no jury, they often want what's called a bench brief or memoranda for the judge. Even when there's a jury, they may want it about the legal issues. So in advance of the trial, the judge reads both sides. It could be a presentation, a little bit of a presentment of the evidence, a little bit of your opening statement, a little bit of talking about some of the legal issues. Here's how they decided to do it. This is on page 3 of the plaintiff's trial brief to the judge right before today's trial started. And I'll report on what happens each day of the 3-day trial. Witnesses will testify at trial, says Oregon, that in the period following the president's September 27th decision, that was to deploy the National Guard in Oregon, federal law enforcement caused the situation to deteriorate by employing indiscriminate, excessive force against small crowds. Even Portland's police officers were caught up in the overreaction. Get this. The cops have been gassed by federal law enforcement. On at least one occasion, an officer was hit by a federal law enforcement projectile. They're shooting pepper balls and tear gas at the cops. Now, the basis for taking over, commandeering the National Guard is Donald Trump's claim that Portland's on fire. Portland's out of control. Portland is smoke-filled. Portland is war-ravaged. Apparently it's being done by the federal officers at ICE. And by creating this chaos of his own making, Donald Trump then tries to benefit from it in order to crush the dissent. That's what we're watching. And this is not unusual. Here's what they said about the other actions. The federal government's needless use of munitions at the facility, the ICE detention center, also created the appearance of smoke, flashes of fire, and explosions, all of which were broadcast on national television. It's no wonder then, after his September 27th decision, that the president sought to bolster his initial assessment with more hyperbolic descriptions of explosions and fire all over the place in Portland, right, of your making. Now, here's what they say at the top of their trial memoranda to set the stage for the trial. The ordinary challenges of governing cannot justify the extraordinary measure defendants employed here. For example, First Amendment protected assemblies, even when combined with limited sporadic episodes of unlawful conduct, do not constitute a rebellion or an inability to execute the laws of the United States. Put another way, unlawful conduct, while inexcusable, is properly managed by regular law enforcement. Its existence does not justify federalizing and deploying military forces in an American city. Nor do ordinary government staffing shortages created by budgetary constraints and shifting policy priorities satisfy the statute's requirements. Those core principles, which guard against both the presidential overreach and domestic militarization that our nation's founders rightly feared, are dispositive in this case. This is exactly an overgrown president using military on domestic soil. That's called tyranny. That's what the framers and the founding fathers were worried about. That's what the Federalist Papers were worried about. That's what's at stake with Judge Immergut. Now, she's got to feel good about herself as a judge and that she got the Ninth Circuit, or the parties got the Ninth Circuit, to throw out the October 20th order that had blocked her decisions and said she was wrong. Ninth Circuit said, not so fast. They're not making a ruling yet, but at least 15 out of the 29 said, we're concerned that maybe that decision was not right, because why else would they grant en banc? If they thought the decision was right, they'd be like, nah, it's not exactly how we would have written it or analyzed it, but it's about right. No. Now let's see how much from the 29 end up. It's going to be the composition of the en banc panel that's going to matter. And they're a majority rules. So if let's say you have 11, 6-5, could be 11-0, but 7-4, any other combination gives you the new ruling. For the Seventh Circuit, who ruled against Donald Trump to see on federalization and nationalization of the federal guard in Illinois, it's still up at the United States Supreme Court on an emergency application. We're 2 weeks in. I'm going to put this video up. Within hours, I could tell you the Supreme Court has ruled. What I think the delay is in waiting on the Supreme Court, frankly, is that they're waiting for the dissents to be written, right? You got the majority opinion, which is usually in an emergency application, a paragraph, but then you have dozens and dozens and dozens of pages written by Sotomayor and Ketanji Brown Jackson and Kagan if they're in the minority, or if for somehow some of the MAGA are in the minority somehow. Then it's, we're waiting on Alito or Thomas or Amy Coney Barrett or Kavanaugh to write something. So they're writing. That's what's going on right now. And in the meantime, they're watching. They know the Ninth Circuit has just blocked effectively the ruling. They know there's a trial in Portland, Oregon, and they're doing their job, and they're doing whatever they're doing. I'll continue to follow it here on Legal AF. Take a minute, boom, hit the subscribe button. Your First Amendment rights are at stake. Our First Amendment rights are at stake. Protect Legal AF from the attacks of the administration by becoming a member. We have no subscriber. We have no outside investors. We have no paywall. But if you come over to Legal AF Substack, which I think you'll really enjoy, where we put up 10 pieces a day, video, audio, all sorts of commentary, that for less than $7 a month, then you can support everything that we do and make sure that we're on the air. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.